Good day, I am Lian Buan and this is Rappler Talk. We have here today Attorney Carlo Cruz, one of the spokespersons of Chief Justice Justice Sereno, who is facing an impeachment complaint before the House of Representatives. Earlier this week, they filed a verified answer before the House Committee on Justice to answer the allegations by lawyer Larry Gadon. We will try to dissect the issues that are covered in your verified answer, sir.
Good day, Lian.
Good day po. Sir, I'll go straight to Piatco because
Yes,
Attorney Gordon is saying might be his strongest accusation because it's SALN, it involves SALN. Sir, in 2010, when she was appointed Associate Justice of Supreme Court, she declared a net worth of 17.9 million. Ang tanong po, dito po ba sa 17.9, sabi nyo nga po, what remained of the 30 million fees from Piatco that she got from 2004 to 2009, ay kung anong natira, yun lang yung dineclare niya in 2010. So dito po sa 17.9 million na dineclare niya noong 2010, meron po ba siyang ibang earnings aside from Piatco?
During that intervening period, of course, I would imagine. She was a practicing attorney then. But here's the thing, the requirement for the disclosure of assets, I'm sure she would have addressed it properly. You know, Lian, no? You distinguish the concept of earnings from the concept of assets because the requirement, both under the Constitution and the law, is to disclose assets upon assumption into office and thereafter periodically. My sense here is that the Chief Justice, yes, disclosed all of her earnings and not only the professional fees she would have derived from her services in the Piatco transaction. No? My statement here is that yes, she would have disclosed or included, if they were still assets, earnings that she would have, made during the intervening period.
Sir, briefly lang, let's explain to the public why yung 30 million hindi naka-declare ng buo nung 2010 up to now.
You know, first point that I would like to stress, contrary to popular misimpression, that amount, a little less than 31 million, no? She earned it over a period of 5 years as counsel. Now, the rate that she charged was far less than the regular rates assessed or charged by her foreign counterparts. So she worked hard for these fees. Third point that I would like to stress is that these fees were paid to her, but there is in that arbitral ruling a directive, a judgment award, if you will, no? Assessing the attorney's fees or professional fees paid as a consequence of that victory as against the losing party. So in a real sense, no, it is not really government which would have paid her those fees. Now, when she or after she worked for 5 years, earned that amount, well, she lived. No, they bought a modest home, a modest vehicle. They equipped that modest home with furniture. Well, there was a little sadness in their family then. Father, mother had went through some medical difficulties and they eventually passed on. Well, it was the Serenos who spent for the medical expenses and the funeral expenses. And the Sereno spouses are very devoted to their church and they have been giving regularly, as expected of all devoted members of the congregation, their tithes, their love offerings. Now, and they also, as I stressed earlier, live. No? We have this family overhead expenses. And I think the answer pretty much sums up and more than adequately addresses or accounts for all of those amounts prior to her entry in the Supreme Court. I think Attorney Alex Poblador did an excellent job explaining this. The point we would like to drive home is this. We hope our countrymen and our friends in the House would understand that there must be a distinction between earnings, because earnings are not required to be reported. Taxes, all of them were paid on these earnings, no? The requirement is to disclose
taxes
assets.
Through the income tax return?
Yes, upon receipt of any and all the fees that she would have received, no? She would be subject to withholding taxes, and then she would include the remaining amounts in her final ITR, accumulated with her other income as required of every citizen. You know, all the documents are there, the income tax returns and everything. This would essentially show to the public that this particular allegation of Attorney Gadon appears to be have been made on the basis of perhaps misinformation.
Sir, the issue of wealth of public officials is very controversial nowadays.
Of course.
If we get to the point that people demand that Chief Justice Sereno sign a bank waiver, would she?
You know, well, as a person, as a lawyer, she does understand the import or the significance of the bank secrecy law. I'm sure she has her specific concerns, but I think I should try and make the people understand here that ever since Attorney Poblador took over the case, no, well, the Chief Justice, being the wise lawyer that she is, I think has every intention of being an obedient client. So in this regard, I should state that she would be guided by advice of counsel. And so we will leave it up to Attorney
So,
Podol.
sir, what is the inclination of the counsel?
Lian, I will tell you this, no? I do not see any point. I do not see this issue as arising because there was never any allegation to the effect that there was a disclosure of income during or wealth during her incumbency as a member of the Supreme Court. Now, technically, from the legal perspective, evidence-wise, maybe that the disclosures as to bank accounts may be relevant. But no, the allegations here were with respect to her earnings long before she entered. There is no issue as to corruption committed by her during her incumbency. So, from my meager experience as a lawyer, no, I don't think that there would be any reason for this issue to ever arise at all, or at least it would be warranted. Now, if there,
You don't see it getting to that point that she's required?
well, I hope not. No, there can be playful minds in these proceedings, and they may test the waters. But I think that our friends in Congress, both in the lower house and in the Senate, would be able to understand an issue, a non-issue, from a real one. Now, we have to have placed confidence in our legislators because to them has been entrusted the task of acting as judges here. Well, I would like to quote my sister, Candy, by way of paraphrase. We have every confidence that they would be reasonable minds and address this particular process or proceeding with a full cognizance full realization of the importance of their role.
Sir, if she is asked to sign a bank waiver, would the Chief Justice
Yes,
do
I
it?
have learned this from one of my colleagues as spokespersons, no, that there is a waiver in her accomplished and submitted statements of assets and liabilities consistent with the law to the effect that she is waiving her rights with respect to documents that may be required of the Ombudsman in connection with any investigation that the Ombudsman may decide to pursue against her, if and when that happens.
Sir, another controversial issue nowadays is what are public officials required to put in their SALN? And I saw the Chief Justice's SALN, wala pong mga value yung mga financial investments niya like in Seaport, PLDT. Could you enlighten us? Is this required?
Well,
Is this not required?
I have been away from public office for a long time. My understanding is that the matter of preparing the SALN has become a very complicated and tedious process, no? I would not want to indicate in this conversation the specific requirements. But here's the point, Lian, no? She did not make any effort not to disclose all of these investments. They were specified in the answer. They are indicated, I don't know if, I have not seen the SALN, no? But if you say that they were indicated in general terms, maybe, the bottom line figure is there anyway. And I don't think there would be any problem in the Chief Justice's specification of all of these items listed as investments. She has the documents, and these are, I imagine, evidenced by certificates of stock. There can be no non-disclosure with respect to these things.
Sir, enlighten us also, bakit daw po kaya hindi nag-divest ang Chief Justice from her
Well,
financial
is there a need for her to divest? We are all telephone subscribers and therefore shareholders of PLDT. Is there need to divest? As far as I know, there is no requirement for divestment in this regard. And besides, my understanding is that these investments in the context of big business, etc., they would be considered perhaps as minimal. Things that perhaps she's a lawyer. I don't think she's a businessman. Maybe it was because only of discussions with friends that this may be a good investment. But this is by no means a matter that is really of serious concern in terms of the Chief
Sir,
Justice.
paano daw po kung nagkakaso itong mga kumpanyang ito sa Supreme Court?
Well, I think in the first place, I doubt very much if she would have any majority shareholding here. My thinking here is that like a PLDT subscription because of PLDT landlines installed in our homes, this would be nominal. But I imagine, if there were a serious concern regarding potential conflict of interest, well, the Chief Justice, let's give her a little credit here. I hope that she will be given that little credit, to have the good sense, and I think she would do this, to recuse herself, to inhibit herself from the proceedings. I don't think she would have any problem there. And for all I know, she may have done so already in connection with some cases.
Sir, let's go to the issue of the resolutions inside the Supreme Court na isa rin sa mga sinasite ni Atty. Gadon. One of them is the RCAO, the ARCAO, yung pong pag-revive ng ARCAO ni Chief Justice Sereno, which was disputed by Justice Teresita Leonardo de Castro. Tapos parang nagsabi na nag-issue daw ng nag-issue ng corrective resolution. But in your verified answer, you said, hindi naman nag-issue ng corrective resolution. What she issued was a resolution addressing the problems when the ARCA was piloted.
Right.
To the public po kasi baka it would appear that bakit yung unang resolution ni Chief Justice, bakit hindi na-address kaagad? Parang baka sa perspective ng tao, nagkamali siya, napagalitan ni Justice De Castro, kaya nag-issue ng bago. And this is what Larry Gadon also said in his complaint na tongue lashing daw ang inabot ni Chief Justice from Justice
alam
De
mo,
Castro.
those statements are very, for me, very sad. You use the word napagalitan daw ni Justice De Castro. I think this is one thing that I have to be quite emphatic upon. The Supreme Court is composed of learned men and women. Personally, I have always maintained this. I've addressed this in all of my conversations with your friends in mass media. I have the highest regard, the highest respect for all of them. But here's my point. That RCAO thing pertains to internal rules by way of implementation by the Chief Justice because after all, she is the designated administrator. All lawyers would have varying interpretations on specific rules and laws. But the point is this, the operative word here is internal, all right? In this case, the ARCAO, my understanding is that there is a general internal rule to the effect that the Chief Justice is given a wide latitude of discretion with respect to implementation of these administrative matters. There is need to consult the NBank if there were a policy change. That is my basic understanding. But may I revert to my point? These are internal matters. And they are brethren. If Justice De Castro would have taken exception to the administrative action of the Chief Justice in this regard, well, the fact that she was able to air it and the fact that it may have been tackled in an en-banc session, well, that for me is great because that is an indication that the internal system or processes within the Supreme Court, which by the way, I should stress, is a collegial body, it's working, Nian. The fact that these brethren may have disagreements, that is the essence of an en-banc session. That is why there are many different minds that comprise the Supreme Court. If they have disagreements, if they have different approaches that they would like to pursue, here's the thing. We should let the court as a collegial body address all of these disagreements as a body. There may be or there should perhaps be no need for a co-equal branch of government to involve itself in the internal workings of a collegial, independent body. The fact that you mentioned that Justice De Castro was able to voice out her concerns regarding this ARCAO administrative action of the Chief Justice, for me, only serves to indicate that their processes are working. You get my point,
Yes,
Ian?
po, yes.
So, there will always be disagreements among great minds. And that is, for me, wonderful. So, that's my point, Lian.
Sir, baka to the public kasi ang perception sa kanila, while there are disagreements and we say that we celebrate the disagreements in the SC, baka ang dating ay, bakit lagi na lang kinukontra si Chief Justice? Because recently may memorandum ulit si Justice De Castro disputing a lot of her actions like the appointment of the PNC head, the travel
but how many
allowance.
of those memoranda, how many of those ponentias of her were the subjects of full agreement by her brethren. You know, we focus on the negative things, but you know, this most productive court has resulted in many ponencias, meaning decisions of the Chief Justice, which were unanimously supported by her brethren. So you see how it works, no? Right now, there is this impeachment complaint against her. So it is so easy for the public to focus on the divisions, the dissensions. But it is best remembered, there are also agreements, there are also there is also instances of unanimity among the entire court. Well, you have to temper these considerations. We cannot proceed, Lian, you have to understand, in terms of perceptions. You know, the point is this, assuming there were internal strife, no? Does that rise to the level of an impeachable offense? Well, we respectfully submit that it does not. And that is one of our main points.
I remember Attorney Alex Poblador saying in the last press conference that these matters are just a disagreement of the extent of the administrative power of
Precisely.
the Chief Justice.
Precisely.
Sir, do you remember a former Chief Justice that got this much contention to how, kung ano lang yung cover ng administrative power niyo, or is this Chief Justice Sereno the first time na a Chief Justice is experiencing this?
I'll tell you this, no, I am not privy to the workings or goings on in the Supreme Court. But I'll tell you this from a practical perspective. Every leader has his problems. Every administrator is besieged with disagreements regarding interpretations on administrative actions. I think it would not be correct to say that Chief Justice Sereno her case is peculiar, that she is the only Chief Justice who has been besieged with problems of this character. You know, even during those days of Chief Justice Fernando, Chief Justice Narvaza, I am certain that they were also faced administrative disagreements of this character.
Sir, let's go to the newspaper reports which make up bulk of Larry Gadon's complaint. And you already said, and we're aware na in a court proceeding, these are hearsay evidence.
Yes.
Pero baka po sa tingin ng public, kasi the newspaper reports, the sources are within the SC itself. Minsan, sometimes it's the justices are the sources pa. So ano po kaya yung parang, it paints a picture of Chief Justice Sereno with her staff or colleagues leaking information against her.
Alam mo, Lian, you know, we are not prepared to join this bandwagon of thinking, this chorus na saying that there were leaks in the Supreme Court and the leaks now would be members of the court or colleagues of the court. This is for Attorney Gadon to explain, no? We will not join the chorus and simply say, without any evidence whatsoever, that the information that is being leaked would emanate from members of the court itself, because that is a very serious accusation, and it would be very irresponsible of us to, you know, even lean toward that. My point is this, no? It is Attorney Gadon who made the basic allegations here. He is the one who has presented certain documents, unauthenticated or not. I'm not certain at this point, no? I think at the first instance, it is Attorney Gadon who should explain as to who disclosed these pieces of information to him, because it would be, after all, relevant to the determination of whether or not he has personal knowledge. And, you know, if there were indeed leakages, as the public may perceive, no? Well, I think this is a matter that must be addressed by the court as a collegial body. They have to be secure in their processes. And I think this is a matter that should not concern only the public, but the court as a body as well. Now, this is serious, di ba?
Sir, I'll push the question some more. Sabi ulit ni Attorney Gadon, he has at least 6 justices who have committed to testify against Chief Justice Sereno. Do you know how she feels about this kinds of pronouncements?
Well, this much I will tell you in my limited conversations with her, no? But this was pronounced in our conversations. No? We have the highest respect. We have the highest admiration for all members of the Supreme Court. I know some of them personally, and I have always admired those whom I know personally. No? My point is, if they have something to say about these proceedings, by all means, the nation should listen. By all means, our friends in the House Committee, they should assess what they have to offer, if they have anything to offer. But I just hope that this particular consideration would be tempered by an equally important consideration that if they speak, the Chief Justice should be allowed to respond. That is all.
Sir, when you say she should be allowed to respond, sasalang din po ba siya sa...
No. Respond in
Through
any
your
means that are allowed.
pleadings.
No, but essentially, I think she will do it by cross-examination of counsel of the honorable justices of the Supreme Court. We hope for that the committee would allow this. No. After all, what are we all after, Lian? We are after the truth. Certainly, frowning upon the possibility that members of the court would testify would do us no good. In fact, it should be encouraged if the rules of the Supreme Court would allow it, if they really have a sincere concern, a serious one, then by all means we should listen to them. And the Chief Justice is confident, as she has displayed and expressly indicated in her answer, she is confident that she will be able to adequately and properly reply to all of these testimonies that her colleagues may offer.
Sir, another issue is the issue of doing away with the SC recommendation for applicants. And the Chief Justice said 3 justices went to her in confidence to say yung position nila. And you said in your verified answer, she
Again,
will name
yes.
them in the proper. So,
Leah, may I point this out at the outset, no? Again, this is an allegation, no? It must be supported by proof, and then the burden of proof at this point rests on the shoulders of Attorney Godon. He has disclosed by way of allegation an internal matter again in the Supreme Court. While the Chief Justice may be prepared to present counter evidence in this regard, there may be no need for her to do so if Attorney Godon is not able to substantiate this particular matter, which I repeat, is supposed to be a confidential issue or confidential action of the Supreme Court.
sir, would there be justices who will be willing to testify for the Chief
I'll put it
Justice?
this way. As much as possible, and this is clear from my conversation with the Chief Justice, our purpose in participating in these proceedings is because as Chief Justice, she has to uphold the Constitution. She has to abide by the rules of the House and the laws that may be pertinent here. The thing that we would avoid the most is to give any impression in the minds of our countrymen that she will be engaging in a brawl, in a street gutter fight. No, that would not become the position of she will do what becomes her as a Chief Justice. She will proceed with dignity as is her duty. She will proceed in an honorable manner. We will not engage in fisticuffs in the sense or in the context that the public has, there is some perception that is what may happen. Leanne, you have to understand, we will not do that.
Sir, one more time, will Chief Justice Sereno resign? Is she thinking about resigning?
Never an option, never considered, because this is not just about Maylu Sereno. This is about the office of the Chief Justice. Well, the dignity attached to the office, it must be defended. It must be maintained. This is beyond the office of the Chief Justice about judicial independence. As Chief Justice and as a lawyer, it is their duty to address this, face this squarely, counter it with nothing but the truth. So, resignation, it was never an option. I hope I have adequately addressed your concerns.
Yes, sir. Thank you so much. That has been Attorney Carlo Cruz, one of the spokespersons for Chief Justice Maria Lourdes Sereno. I am Lian Buan. This has been Rappler Talk. Thank you for watching.